અને મહત્વપૂર્ણ સમાચાર સામે આવી રહ્યા છે। દિલ્હીમાં કેન્દ્ર રાજ્યના પાવર પર ચુકાદો। જી હા, સરકારના અધિકારીને લઈને સુપ્રીમ કોર્ટમાં સુનાવણી। 2019ના નિર્ણયથી સહમતિ ન હોવાનું સીજીઆઈએ સ્પષ્ટ કર્યું છે। સીજીઆઈએ કહ્યું કે બહુમતના આધારે આ નિર્ણય થયો છે। તો ખૂબ જ મહત્વપૂર્ણ સમાચાર સામે આવી રહ્યા છે। દિલ્હીમાં કેન્દ્ર અને રાજ્યના પાવર પર ચુકાદો।
The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in lists 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accountable to the people of NCTD. Under the constitutional scheme, NCTD was given legislative power which, though limited in many aspects, is similar to states. In that sense, with the addition of Article 239AA, the Constitution created a federal model with the Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the Union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is a concurrent list, the Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament. Therefore, the executive power of NCTD in the absence of a law by Parliament shall extend to all subjects on which it has power to legislate. It was held Then we cover Rule 46 of the rules, and we say, the rule provides that the Lieutenant Governor shall exercise such powers and functions with respect to persons serving in the administration of NCTD as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President. The term administration in this rule must be considered in the context of Article 239 AA3 and Section 41 of the GNCTD Act. The executive administration by the Lieutenant Governor, in his discretion, can only extend to matters which fall outside the purview of the powers conferred on the Legislative Assembly, but it extends to powers or functions entrusted or delegated to him by the President, or in which he is required by or under law to act in his discretion or to exercise any judicial or quasi-judicial functions. The term administration cannot be understood as the entire administration of GNCTD. Otherwise, the purpose of giving powers to a constitutionally recognized and democratically elected government would be diluted. In a democratic form of government, the real power of administration must reside in the elected arm of the state, subject to the confines of the Constitution. A constitutionally entrenched and democratically elected government needs to have control over its administration. The administration comprises of several public officers who are posted in the services of a particular government, irrespective of whether or not that government was involved in their recruitment. For instance, an officer recruited by a particular government may serve on deputation with another government. If a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying the triple chain of collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. The principle of collective responsibility extends to the responsibility of officers who in turn report to the ministers. If the officers stop reporting to the ministers or do not abide by their directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. We have already held that the relationship between the Union and the NCTD resembles an asymmetric federal model, where the latter exercises its legislative and executive control in specified areas of the state list and concurrent list. Article 239 AA, which conferred a special status to NCTD and constitutionally entrenched a representative form of government, was incorporated in the Constitution in the spirit of federalism, with the aim that the residents of the capital city must have a voice in how they are to be governed. It is the responsibility of the government of the NCTD to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive who are charged with formulating.
તો સૌથી મોટા સમાચાર સામે આવી રહ્યા છે દિલ્હીમાં કેન્દ્ર અને રાજ્યના પાવર પર કે દિલ્હીનો પાવર આખરે કોના હાથમાં તેને લઈને સુપ્રીમ કોર્ટમાં સુનાવણી. સુપ્રીમ કોર્ટમાં આજે આ મામલે ચુકાદો આવશે કે દિલ્હીમાં સરકારના અધિકાર કોને આપવામાં આવશે. બહુમતના આધારે આ નિર્ણય થાય છે. 2019ના નિર્ણયથી સહમત ન હોવાનું પણ CJIએ સ્પષ્ટ કર્યું છે. 2019માં કેન્દ્ર સરકારને વધુ અધિકાર મળ્યા હતા અને તે બાદ 2021માં એક ખાસ બિલ પણ પસાર કરવામાં આવ્યું હતું, જ્યાં દિલ્હીના LGને ખાસ અધિકારો, વધારાના અધિકારો પણ સોંપવામાં આવ્યા હતા. જો કે આમ આદમી પાર્ટી સરકાર, દિલ્હીની સરકાર આ મામલે સતત વિરોધ કરી રહી છે. તેમણે સુપ્રીમ કોર્ટમાં અરજી દાખલ કરી હતી, તેના પર સુનાવણી આજે થઈ રહી છે. સુપ્રીમ કોર્ટના જજોનું કહેવું છે કે લોકતંત્રને બંધારણીય માળખાની જરૂર છે. દખલથી રાજ્યનું કામ પ્રભાવિત ન થાય તેનું ધ્યાન રાખવાની જવાબદારી પણ કેન્દ્ર સરકારની છે. ચૂંટાયેલી